At a rehabilitation and skilled care center outside Boston, roughly 115 elderly residents are cared for every day by a staff that includes dietary aides and certified nursing assistants, some of whom have worked there for years, building the kind of trust that does not come from a job posting. It comes from showing up every single day for someone who cannot always advocate for themselves, remembering how someone likes their coffee or which resident gets anxious during a shift change and needs a familiar face nearby. In the last 2 weeks, the people running that facility have been trying to figure out how much longer some of those specific staff members are legally allowed to keep working. Not because anyone did anything wrong, not because of any performance issue or disciplinary problem, but because of a Supreme Court ruling that has nothing to do with elder care on its face and everything to do with it in practice. If you have a parent in assisted living, if you work in senior care yourself, or if you are simply trying to understand why nursing homes and assisted living communities across the country are suddenly bracing for a staffing crisis, this is the ruling you need to understand, using what the court actually said, not the shorthand version already spreading online, and not the vague, unsourced claims about an imaginary elder care bill that have been circulating on video platforms this month, because that is not what actually happened here. And chasing the wrong story means missing the real one sitting right underneath it. Quick thing before we get into it. I cover Supreme Court decisions and policy changes that actually affect seniors and the people who care for them, the moment they happen, not weeks later, and not filtered through a title that gets the basic facts of what the court actually does wrong. If that is useful, subscribe and turn on the bell, because the practical fallout from this ruling is still unfolding right now, facility by facility. 2 seconds? And let's get into what actually happened. On June 25, 2026, the Supreme Court decided a case called Mullin versus Doe, consolidated with a companion case called Trump versus Myatt in a 6-3 ruling. The case is about a federal program called Temporary Protected Status, TPS for short, which Congress created in 1990 to give people from countries facing war, natural disaster, or other extraordinary danger a legal right to live and work in the United States for as long as their home country remains unsafe. Haiti received a TPS designation in 2010, after an earthquake that killed or injured hundreds of thousands of people. Syria received its designation in 2012 because of the government and military's violent repression of its own civilian population. Over the years since, those designations have been renewed repeatedly, which is exactly why, even though TPS was designed as short-term relief, in practice it has often lasted many years, long enough for people to build careers, homes, and families here. It helps to understand how TPS actually works day to day, because it is different from other forms of immigration status people sometimes confuse it with. TPS is not a path to a green card or citizenship on its own, and it never has been. It is a renewable work permit and protection from deportation, tied specifically to conditions in a person's home country rather than anything about their individual case, which means the same decision that ends TPS for one person ends it for every TPS holder from that country at once, regardless of how long they have been here, how much they have contributed, or how established their life has become. A Secretary of Homeland Security reviews conditions in each designated country periodically and decides whether to extend, redesignate, or terminate that country's status. That structure is precisely what put so much power in one office's hands, and precisely what this lawsuit was trying to get a court to check. Last year, then Secretary of Homeland Security Kristi Noem, acting on the direction of the Trump administration, moved to terminate the TPS designations for both Haiti and Syria, declaring that conditions in both countries had improved enough that the protection was no longer necessary. Haitian and Syrian TPS holders sued, and this is the part that actually matters for understanding today's ruling. They did not just argue that the decision was wrong on the merits. They argued the Secretary had failed to follow the correct legal process in reaching it, and in one of the two cases, that the decision to specifically end Haiti's protection was motivated by the racial makeup of that country's population rather than any genuine assessment of safety. A federal judge in Washington, D.C., Judge Ana C. Reyes, agreed with the challengers back in February and blocked the termination from taking effect while the case proceeded, finding that the Secretary lacked the authority to end the designation the way she did, and that her stated reasoning for doing so did not hold up to scrutiny. A federal appeals court in New York reached a similar conclusion in the companion Syria case, going so far as to describe the administration's handling of that termination as part of a broader pattern in its immigration enforcement approach, and it declined the government's request to pause its own ruling while the case moved forward, leaving the Syria termination on hold at the same time the Haiti termination was separately blocked in Washington. The government asked the Supreme Court to step in on an emergency basis, and rather than simply ruling on the emergency request, the court took the more unusual step of agreeing to hear the full case on an expedited basis, hearing oral argument on April 29, 2026, and issuing its final decision less than 2 months later. Here is exactly what the court held. Writing for the majority, Justice Samuel Alito concluded that the actual text of the TPS statute bars federal courts from reviewing almost any non-constitutional legal challenge to a secretary's decision to end a country's TPS designation. The court read the word determination, as used in the law, broadly enough to cover not just the secretary's final decision, but the entire process that led to it, meaning even claims that the secretary failed to follow required procedures are now largely outside what a court is allowed to second-guess. Chief Justice Roberts and Justices Thomas and Kavanaugh joined that reasoning in full, with Justices Gorsuch and Barrett joining most of the opinion as well, for a 6-justice majority overall. On the one constitutional claim actually before the court, the argument that Haiti's termination was driven by race, the majority found that claim unlikely to succeed, pointing in part to the fact that the administration terminated TPS designations for 13 countries around the same time, which it treated as a race-neutral explanation for the timing. It is worth knowing that the lower court, which had originally blocked the termination, reached the opposite conclusion on this exact question, citing public statements made by both the President and then Secretary Noem about Haitian immigrants specifically, statements the district judge characterized as evidence that racial animus, not a genuine safety assessment, was driving the decision. The Supreme Court did not rule that those statements were irrelevant or untrue. It ruled that, weighed against the broader context of 13 simultaneous terminations, the claim as a whole was unlikely to ultimately succeed. A narrower and more technical conclusion than either side's public messaging about the ruling has generally conveyed. Justice Elena Kagan dissented, joined by Justices Sonia Sotomayor and Ketanji Brown Jackson, the same 3 justices who make up the court's current liberal wing on most closely divided cases. The dissent's core objection is that reading the statute, this broadly effectively hands the Secretary of Homeland Security unchecked power over a program affecting hundreds of thousands of people, with no meaningful court oversight even in cases involving serious procedural failures or allegations of discriminatory intent. Kagan argued that Congress could not plausibly have intended to insulate every single step of the Secretary's decision-making process from any judicial scrutiny whatsoever, and that the majority's broad reading of the word determination goes well beyond what the statute's text actually requires, effectively converting a narrow limit on review into something closer to a blanket shield. The majority actually acknowledged the force of this concern directly in the opinion, noting that its reading could, in theory, protect real abuses of the TPS process, like an arbitrarily short designation or a termination based on nothing more than a coin flip, but concluded that if Congress disagrees with how much discretion the law gives the Secretary, changing that is Congress's job, through legislation, not the court's job to fix by reinterpreting the statute more narrowly than its text supports. The practical effect is direct and immediate. The ruling clears the legal roadblocks that had been keeping Haiti and Syria's TPS terminations on hold, meaning the Department of Homeland Security can now proceed with ending protected status and work authorization for roughly 350,000 Haitian nationals and roughly 6,000 Syrian nationals. As of this recording, U.S. Citizenship and Immigration Services has been directing employers to treat July 1, 2026 as the work authorization expiration date for both groups on employment verification paperwork, though the exact effective date has some genuine uncertainty built in, since the Supreme Court's formal mandate does not issue immediately and DHS has some latitude in how it sequences the rollout. Employers are being told in industry guidance to continue honoring currently valid work permits until DHS issues further clarification, and not to take adverse action against employees based on the ruling alone, which is a meaningful distinction if you or someone you know works in a facility currently navigating this transition. Some reporting since the ruling indicates work authorization for at least some Haitian TPS holders has already been administratively extended a short distance, to July 10th, underscoring that the exact timeline is still being finalized even as the underlying legal question is now settled. Now here is why any of this belongs in a video aimed at seniors and their families rather than strictly an immigration or legal channel. Haitian immigrants in particular are heavily concentrated in the healthcare and elder care workforce, and industry groups have been sounding the alarm since the moment this ruling came down. Leading Age, the national association representing nonprofit senior living and care providers, said that legal caregivers currently represent 8% or more of the entire workforce in some of its member communities, and that there is, in the association's own words, no workforce waiting in the wings to immediately replace them, a phrase its president and CEO used specifically to describe relationships between residents and caregivers built over years, sometimes decades, that cannot simply be reassigned to a new hire overnight, even if a replacement were readily available. The American Seniors Housing Association issued a similar warning, describing the ruling as creating immediate workforce uncertainty, specifically within healthcare and long-term care roles. At Goodwin Living, a senior living nonprofit serving thousands of older adults across Northern Virginia and Washington, D.C., leadership began bracing for staff cuts within days of the decision. At that rehabilitation center outside Boston I mentioned at the start, administrators were racing to determine exactly how much longer specific staff members, the same dietary aides and certified nursing assistants who care for their roughly 115 residents day to day, could legally continue working. Ohio offers a specific, concrete preview of what this looks like at the community level, because the state is home to two cities, Springfield and Columbus, with unusually large Haitian populations, many of whom work in caregiving and manufacturing roles. Advocates in the state have already flagged a specific, immediate consequence beyond employment itself, that affected residents could lose the ability to renew or even apply for a driver's license within days of the work authorization change taking effect, since license eligibility in many states is tied directly to proof of current legal work authorization. For a home health aide who drives between multiple senior clients' houses each day, or a nursing assistant commuting to a facility on a fixed shift schedule, losing driving privileges is not a side issue. It is often the thing that ends their ability to work at all, even faster than the loss of the underlying work authorization itself. This is not a hypothetical concern layered on top of the ruling for dramatic effect. It is a direct, acknowledged consequence of how concentrated this particular workforce is in this particular industry. Healthcare has been the fastest growing sector of the American economy for years, and it already runs a higher vacancy rate than almost any other industry, which means the ordinary process of simply hiring replacement workers on short notice is significantly harder here than it would be in a lower skill, higher supply labor market. If you or someone you love currently receives care from a home health aide, a nursing assistant, or staff at an assisted living or skilled nursing facility, the honest, practical action step is to ask that facility directly, and soon, whether any of the staff involved in your care are affected by this specific ruling, and what contingency plan the facility has in place if some of its current staff lose work authorization in the coming weeks. The reaction to this ruling has broken down along fairly predictable lines, and it is worth hearing both directly rather than through a filter. DHS General Counsel James Percival characterized the decision as a vindication of the rule of law, and a White House spokesperson reiterated that TPS was designed as temporary relief, never intended as a permanent pathway to residency, framing the ruling as simply enforcing the program as Congress originally wrote it. On the other side, advocacy organizations, including the NAACP, Global Refuge, and the Haitian Bridge Alliance strongly criticized the decision, with NAACP President Derek Johnson calling it a betrayal of Haitian families who have lived and worked in the United States for years. Global Refuge's president, Krishomara Vignaraja, made a specific, narrower point worth understanding on its own terms, that the court did not actually rule Haiti or Syria are safe to return to, only that the safety question itself is not something a federal court is allowed to second-guess, a distinction between the legal outcome and the underlying factual reality that gets lost in most of the surrounding commentary. New York Attorney General Letitia James also condemned the ruling. It is worth noting that even officials who support the underlying policy have distinguished it from the legal question actually before the court. Ohio Governor Mike DeWine, a Republican who had previously called the administration's approach to ending these protections a mistake, described the Supreme Court's ruling itself as simply a legal decision interpreting the statute Congress wrote, while separately maintaining his opposition to the policy outcome. That distinction between whether the court read the law correctly and whether the underlying policy is wise is one worth holding on to as this story continues to develop, because conflating the two is exactly how misinformation about a ruling like this tends to spread. There is also a political thread still in motion that could still change the practical outcome here, separate from the court's ruling. Earlier this year, a group of House Republicans, including Congressman Mike Lawler of New York, broke from their party to help pass legislation in the House that would extend Haitians' TPS protection through April of 2029. That bill has not become law. It would still need Senate passage and the president's signature, but Leading Age and other senior care advocacy groups have specifically urged the Senate to take it up as a direct response to the workforce disruption this ruling is now causing. Lawler himself, representing a district in the New York suburbs, has publicly warned that the ruling will create what he called a crisis in healthcare, a notable statement given that he sits within the president's own party, and it is a reminder that this issue does not divide neatly along the usual party lines once the specific local consequences for hospitals and nursing homes in a member's own district come into view. This means the ruling, while legally final on the judicial review question, does not necessarily mean the underlying protections are permanently gone. Congress retains the power to legislate a different outcome if it chooses to, a point the majority opinion itself explicitly acknowledged when it noted that lawmakers, not the courts, hold the tools to revisit how much discretion the Secretary of Homeland Security has under this statute. Beyond Haiti and Syria specifically, this ruling's reach is broader than the two countries directly involved, because the court's holding rests on how the TPS statute's judicial review provision is written generally, not on anything specific to Haiti or Syria. Legal analysts widely expect it to significantly weaken pending court challenges covering TPS holders from other countries as well, potentially affecting close to 1.3 million people across 17 nationalities in total. Litigation covering TPS holders from Burma, Ethiopia, Nepal, Somalia, South Sudan, Venezuela, Yemen, Honduras, and Nicaragua is currently pending in various stages, and this ruling's interpretation of the judicial review bar makes each of those cases considerably harder for the challengers to win going forward, even though none of them are directly decided by Mullin versus Doe itself. As of this recording, TPS designations that remain valid and unaffected include El Salvador, running through September 9th, Sudan and Ukraine, both running through October 19th, and Lebanon running through November 27th, though the legal environment around all of them has shifted following this decision. And the workforce implications for elder care providers likely extend to those nationalities in the same industries as well, not just Haitian and Syrian workers specifically. Several of these countries also have meaningful representation in healthcare and caregiving roles in specific regions of the country, which means the elder care staffing story we are covering today is very likely to repeat itself, country by country, as each of those pending cases resolves over the coming months. Before we get to the practical recommendations, let me clear up two claims already circulating about this ruling that go further than what the court actually decided. The first claim is that the Supreme Court ordered the deportation of TPS holders. It did not. The ruling is about who gets to review the Secretary's decision, a federal court or no one. It does not itself order removals, and any individual removal proceedings would still have to follow their own separate legal process. The second claim is that this ruling ends TPS nationwide for every country immediately. It does not directly. The decision resolves the Haiti and Syria cases specifically, though its reasoning about the judicial review bar is expected to make it much harder for TPS holders from other countries to win similar lawsuits going forward, which is different from saying every other country's designation ended this week. Getting that distinction right matters if you are trying to figure out whether a specific caregiver or facility employee is actually affected right now versus somewhere down the line. So here is what I would actually recommend if this affects you or a family member directly. If a parent or loved one is in a nursing home, assisted living community, or receives home health care, contact that provider directly and ask specifically how many of their current staff hold work authorization tied to TPS, and what their staffing contingency plan looks like for the coming months, including whether they are actively recruiting to backfill any anticipated gaps or whether they are considering limiting new admissions the way some facilities have already indicated they might. If you work in senior care yourself and are personally affected by this ruling, contact an immigration attorney promptly because the practical implementation date has some genuine ambiguity in it right now, and getting accurate, individualized guidance matters more than any general summary, including this one, especially since guidance on the exact expiration date has already shifted once since the ruling came down. And regardless of where you land on the underlying policy debate, keep watching this specific story, because between ongoing Senate action on the House-passed extension bill and DHS's own implementation timeline, several pieces of this are still actively moving, not settled, and a facility's staffing picture in August could look meaningfully different from what it looks like today, depending on how those two threads resolve. Step back and look at the actual shape of this story. A Supreme Court ruling about the limits of judicial review over an immigration statute does not sound, on its face, like a senior care story. But because of exactly who fills a large share of frontline caregiving jobs in this country today, it has become one, directly and immediately, for facilities like the one outside Boston, trying to figure out, right now, how many of their most experienced staff they are legally allowed to keep on the schedule next month. That is the actual through line connecting a 9-page statutory interpretation argument about the word determination to a certified nursing assistant's next paycheck. And it is exactly the kind of connection that gets lost when a story gets compressed into a single dramatic headline, or worse, into a title that invents a Supreme Court bill that never existed in the first place, when the real story was sitting in plain sight the whole time, just harder to compress into 6 words. If this helped you understand what is actually happening instead of just the headline, hit like so it reaches other families and caregivers trying to sort through this, and subscribe if you have not, because both the Senate's response to the House-passed extension bill and DHS's own implementation timeline are still developing, and I will be covering both the moment there is real news rather than speculation. This is not a story that wraps up neatly in one video. The Senate has not acted on the extension bill. DHS has not finalized the exact rollout date, and the same legal question is about to be tested against 9 or more other countries' TPS designations in the courts over the coming months. Tell me in the comments whether this affects a facility or a caregiver you personally know, because that tells me exactly how deep to go on the practical, facility-level side of this story next, and whether the follow-up should focus on the Senate bill or on how individual facilities are actually adapting their staffing right now, since both are moving fast enough that either one could be the more urgent story by the time the next video goes up.